All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Whoa, whoa, whoa. Hold on. The judge just dropped the hammer. Sufficient evidence to find you guilty. But wait, we haven't even heard the charges yet. This is like walking into a movie halfway through. What's the backstory here? And why is the defense already saying, yes, ready? Are they rushing to sentencing, or is there more to this plea deal? Stick around, because this is about to get messy.
Yes, ready.
All right, it's calling 2021 CR 11805, State of Texas versus Justin Matthew Somerset. Can I have parties announced for the record for the state?
Marcus Sanders.
For the defense?
Edward Schroeder for Justice Somerset. Justice here.
All right, and are you Mr. Somerset?
Yes, ma'am.
All right, defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client? Defense, have you received all the discovery in this case, and did you review it with your client?
Yes, we had a plea bargain. You want to,
No. The discovery? Have you received all the discovery in this case? Just one moment. That goes to that other file. You signed the discovery acknowledgement?
yes.
Defense? So you've received all the discovery from the state?
Yes, we did.
All right, and did you review that discovery with your client?
Yes, we discussed it all.
All right, the court will find that the state is in compliance with discovery.
There's a
Patience in your pocket, everyone. That's judge speak for this is about to get chaotic. The defense just admitted they got all the discovery. But what's in those documents? And why is the judge snorting at 116? Is this a sign of frustration or just a quirky courtroom habit? Let me know in the comments. Have you ever seen a judge react like this?
amended complaints.
Well, just a moment. We're getting there.
Okay.
Patience in your pocket, everyone. Patience in your pocket. All right, Mr. Somerset, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? All right, I need you to speak up. Counsel, do you waive the reading of the indictment? Do you waive the reading of the indictment?
You don't read, do you?
I thought she was asking you.
So read the charge against you.
Yes, yeah.
He waives it.
All right. State, you filed a motion to amend the indictment, is that correct?
Yes, Judge.
Any objections?
No objection.
All right, State, what is your amendment?
And Judge, we're essentially striking through the old language and amending it to the indictment to read on or about the 28th day of September, 2021.
Hold up. The state just pulled a fast one. They're amending the indictment from deadly weapon firearm to striking with a hand. That's a huge downgrade. The defense is like, yeah, it was just a simple assault, but the judge isn't having it. Why the sudden change? Did the evidence not hold up, or is this a strategic move? And why is the defendant agreeing to this? Something's fishy here.
Justin Matthew Somerset, hereinafter referred to as defendant, did use and exhibit a deadly weapon, namely a firearm, and defendant did intentionally, knowingly, and recklessly cause bodily injury to John Ag, hereinafter referred to as complainant, by displaying the firearm and then striking the complainant with the hand of the defendant.
All right, any objections?
Yes, we've agreed to just, it was just a simple assault.
No, here's my question. What the state has just read, the amending of the indictment, do you have any objection to that?
No, Your Honor.
All right,
No.
State, with that amendment, are you proceeding on the indictment as presented?
Judge, we are not. We are striking through the deadly weapon language. In both I guess we're striking through the did use and exhibit a deadly weapon, namely the firearm, and also by displaying the firearm and then. So we're proceeding as a Class A misdemeanor assault.
Any objection?
No, Your Honor.
All right, Mr. Somerset, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Do you understand what the lesson included? You're charged with an assault bodily injury. That's a Class A misdemeanor. The range of punishment is anywhere from 1 year in the Bear County Jail and up to a $4,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargaining agreement with the state, the court does not have to follow your plea bargaining agreement. If for any reason the court does not follow your plea bargaining agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargaining agreement you were giving up those rights?
Yes, ma'am.
You're giving up your right to a jury trial, to cross-examine witnesses, and to remain silent. That's a lot to give up. But the defendant is signing it all away. Why? Is this a sweet deal, or is he just trying to avoid a worse outcome? And the judge just said the court doesn't have to follow the plea bargain. So what's the catch? If you were in his shoes, would you take this deal?
And did you intend to give up those rights and enter into a plea bargaining agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense? Has your client been able to provide you with any
Yes,
defenses
ma'am,
to
he
this
has,
offense?
he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Your Honor, I believe he is.
Mr. Somerset, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone, just 1 second, sorry. Okay, thank you. Has anyone promised you anything other than the plea bargain agreement to get you to enter the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
I'm sorry?
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on the lesser included offense of assault bodily injury. They're asking that your punishment be assessed at 157 days in the Bear County Jail, and there is no application for community supervision or deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that with your attorney and did you understand it? And did you sign it?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Yes, we understand.
No. Has there been any motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is this a judgment satisfied?
Yes, Judge.
Okay. They're saying that you will receive credit, which I always give credit for any time served. So if it's determined that you have 157 days credit in the Bear County Jail already satisfied, I will show that it's satisfied. Do you understand?
Yes, ma'am.
All right. Then to the less included offense of assault bodily injury as a Class A misdemeanor, how do you plead? Guilty, not guilty, or no contest?
No contest. That's legal speak, for I'm not admitting guilt, but I'm not fighting it either. It's like pleading guilty without saying the words. But why? Is this a tactical move, or is the evidence just too damning, and the state is offering 157 days with credit for time served, so he might walk out today? Is justice being served, or is this just a quick fix?
No contest.
State any evidence to support the defendant's plea.
Yes, State offers State's Exhibit 1 and its attachments.
Any objections?
No, Your Honor.
Mr. Somerset, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney?
Yes.
Did you understand it and did you sign it in all the appropriate places?
Yes, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, ready.
All right, and state, is the complainant aware of how this case is being resolved?
Judge, we attempted to multiple times to get in contact with the complainant. Didn't. We were provided a number from defense counsel. He responded, but then he didn't follow through with our attempts to communicate.
All right. And the court will sentence you to 157 days in the Bear County Jail, give you credit for any time served. The court will show that the judgment is satisfied. Is there anything else from either side with regards to sentencing?
Nothing from the state.
No, Your Honor, that's fine.
All right, I'm going to show you, Mr. Somerset, what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Ms.
You got to start learning how to use your words. Mic drop. The judge isn't just sentencing him. She's giving life advice. But is this case really over? The victim wasn't even notified, and the defendant is walking away with time served. What do you think? Fair outcome, or did the system let someone off easy? Let's debate in the comments.
Somerset, you got to start learning how to use your words to solve any issues. Do you understand?
Yes, ma'am.
Otherwise, it's not going to turn out right for you.
I understood.
All right, good luck to you.
Thank you.
Thank you.
You're welcome.